Sir, may I crave your lordship's kind leave to move an urgent application in a pending public interest litigation? But my kindly sees this was the last order. This is relating to my lord Tarapit Mahashashan, my lord, where there was an order. This is my lord a crematorial and burial ground. This is recorded in the records. Tarapit Mahashashan is my lord very sacred place. Kindly comes to the last page. It is made clear that no other construction except the electronic crematorial shall proceed during the interim. This interim order is as of today. Now, my lord, but in spite of this, my lord, they have, my lord, started construction inside the, my lord, Mahashashan.
You serve and file.
My lord, I'm kindly ask me leave, my lord, so that I can serve, because if I am to file, my lord, we have to give 48 hours, my lord.
No, you leave granted.
Leave. Deep leave.
Lordship, may I to
Yes, tomorrow or day after tomorrow, as your lordship.
It will come. We'll tell you.
Lordship, may I to lift him batch of appeal assigned before your lordship, Justice Joymala Bakchi. Now he is not. When I will later, can I assign it because I am suffering from interim order.
Pardon?
I am suffering from interim order, madam. So kindly assign.
No, actually, we have to do that exercise has to be done. You give a letter to the OST, I'll do it. Please call.
Appellate side, daily list, under the heading for judgment, serial number 1.
দিলে ভালো হয় তো। Dismissed. Madam, may I have a copy of the downloaded copy of the order by?
It will be uploaded. Find it, it will be uploaded.
Yeah, grateful.
Next.
Grateful.
Serial number 2.
My lord, I appeared for the respondents.
My lords, I am appearing in person.
I am
My
told,
lord-
my lord, yesterday the matter has been mentioned before your lordship.
He mentioned it
Yes, my lord.
online.
My lord, I have circulated the letter to my learned
And I
friend.
have told by my junior that it has been mentioned saying that the Ministry of Commerce has given consent.
No.
But yes, and I have seen in the my land junior has seen in the my lord YouTube that it has been mentioned before your lordship.
That's his representation.
No, my lord. I have said
I
that
tell your lordship
that
about this.
I have
first, my
submitted
lord.
a
I have
proposal.
something to say, my lord.
No,
Your
no,
lordship, kindly-
subject to corrections, my lord. I will clear to my learned friend what has happened. I have submitted a proposal to the Ministry Secretary IPP that kindly grant me a consent to this, depending upon the facts of this case, that patent I have applied for patent in the year 2005, and there is a administrative delay of 7 years. So I need a consent for a status quo because there is no law, and by this consent, if I get the interim order, section 53 will be safe and others will not be affected. So in this way, government will not be prejudiced in any manner, and my rights will be also get
All right.
protected.
What is the main appeal about?
My lords.
Before that, your lordship showed to your lordship
lord, we have
one
read
judgment in
petition.
this. And let him place this.
Yes.
Uh.
What is the appeal? Let us
Fine.
see. What was the writ petition for?
My lord, may I take your lordship to the impugned order of the learned single bench?
No, first to show the prayer and the writ petition.
My lords. My lord, in my can was dismissed. It was annexed in the can. Can 1 was dismissed. Yeah.
Can 1 is available.
My lord, in the can 1, my lord.
Page number.
My judgment is at page number 288. My lord is
No, clear.
there in the writ petition.
Page 34.
Yes.
My
35.
My lord, I have prayed for.
We are in the writ petition to it. Paper book, page 18. Page 18.
Paper book is also available. Yes.
Page 18, my lord.
18.
We'll refer the paper book.
Yes.
Page 18.
Page 19 is the relevant page.
Page 80. Yeah.
19 is the relevant page.
For, you have challenged the amendment to section 53 of the Patent Act.
My lords,
Sir, Patent Act also, Diptesh.
my lord.
Oh, it is available here. 89. Diptesh, not required. It is here. 89.
My lords. My lord, my humble submission with
You
regard,
please show us what is 53
my lords.
এখানে আছে
The
annex
section
আছে।
53 says,
page.
my lord, page number 22 of my writ petition.
হুম, হুম,
Page 112.
No, no, ওটা তো বুকে।
Correct?
My lord, in the paper book, page number 22, and in
My lord is right, my lord, page 112.
Page 112,
Yes.
section 54 of the Patent Act.
my lords,
Please read
My lord.
54.
my lord, section 54 is with regard to patent in addition, my lords.
53. is it?
53 is
My
the one to
challenge
tell
is 53.
53 he has challenged Bhairi.
My lord, 53 says, term of the patent, my lord.
Very good.
Subject to the provision of this act, the term of every patent granted after commencement of this Patent Amendment Act 2002, 38 of 2002, and the term of every patent which has not expired and has not ceased to have effect on the date of such commencement under this act shall be 20 years from date of filing of application for patent,
Yes.
my lord. And thereafter, my lord, may I take your lordship to 11A7 of the act.
Mm. 11 capital A subsection 7.
My lord, subsection 7. My lord, as an integrum, there is an integrum, it is an integrum provision until patent has not been granted. So, my lord, herein, kindly seize, my lord, on and from date of publication of the application for patent and until date of grant of patent, in respect of such application, the applicant shall have the like privileges. My lord, may kindly note at this point because I have a submission with regard to like privileges later on. And rights as if patent for the invention had been granted on the date of publication of the application. My lord, there were two kinds of publication. One is pre-grant publication under section 25(1) and post-grant publication after grant of patent, that is 25(2). My lord, provided applicant shall not be entitled to institute any proceeding for infringement until patent has been granted. So what legislature is meaning that until and unless final grant is not given to the applicant, he cannot institute, he cannot enforce that patent, because patent is can only be enforced by way of infringement of suit. It cannot be means treated as a tangible property, my lords. So, my lord, herein as an integrum, legislature is saying that you applicant will have the like privileges on and from date of application. And in the main section, in section 53, it is saying it will be applicable from filing. Patent will be applicable from filing. So, my lord, this has been done with reference to TRIPS agreement. There is an international obligation upon the India that every patent has to be 20 years substantive tenure. I agree with this proposition of learned single judge, wherein Honorable Single Judge has been pleased to observe in paragraph 33 of the impugned order that the term of the patent will be 20 year, shall not end before 20 year. Means it is leaving it open to the legislature to grant more tenure. In the event there is a delay in grant of patent, but in what happened in my writ petition, my lord, the Honorable Single Judge dismissed the writ petition without taking into consideration the present fact involved in this case. Or merely on the basis of the law, my lord, it has been dismissed. So, my lord, kindly seize the letter patent certificate, which has been granted to me by the union. In the paper book, my lord, page number.
Page 42, subject to correction.
Thank
Page
you.
43.
Thank you, sir. Page 43, my lords.
42 and 43.
My lord, kindly seize. Patent number is 254875.
Very good.
Date of filing is 2/5/2005. And date of grant is in below the signature of the
2812.
28/12/2012. So, my lord, it is apparent there is a 7-year delay, which has not been dealt with by the Honorable Single Judge. There is no provision to extend, my lord, patent. I agree with this proposition. In the present mechanism, there is no provision. But the issue is that due to administrative delay, consequences has been fallen upon the petitioner. This is my substantive submission, and that was not taken into consideration by the Honorable Single Bench. My lord, thereafter, my lord, may I take your lordship to the impugned judgment of the Honorable Single Judge? Memo of appeal.
Page 288, my lord, of the other paper book.
Volume 2.
My lord, in the memo of appeal,
288.
Yes.
wait, the second volume.
Yes.
My lord. My lord, may I take your lordship? My lord, in this order, there is no iota of any submissions recorded with regard to the present fact that my patent has been applied on 2005 and it has been granted in 12.
2012.
My lord, may I take your lordship to the trips on the basis of
before
which it
that-
has been dismissed?
Before that, on what ground you challenge section 53?
My lord, the section 53 is ultra virus to the Constitution on the basis of Article 20, Clause 2 and Article 20, Clause 3 and right to equal protection, Article 20. My lord, every applicant in India has the right to get the equal protection of law before the court. The issue is that government is trying to protect, but the problem is that the TRIPS agreement, which is binding upon India, mandates that every applicant has to get 20 years substantive tenure. So what government has to do, that they must have to fix, they have to say what are the like privileges they are granting after application of the patent. Because when we apply for a patent, till now I have applied for 3 numbers of patent, and it has not been, I have filed all my documents and submissions with regard to the FER. They have not examined. The file was not open, and my tenure is getting killed. And now when later on stage, when I go to the court, the government will say that you have enjoyed the like privileges. You are entitled for the damages. So my lord, if I don't want to take the damages, I want my tenure, then government is not having any solution for this in this act. The government will say that you go file a suit and get a retrospective damages. My lord, this is not a solution. This is an infringement proceeding. My lord, suppose if I file an infringement suit against a person A who is doing business now, during I have the patent for the argument's sake, and this person closes the business today, and after 10 years,
Yes.
I will file a suit against that person A. How can I get the damages? That has to be looked into by the government. Secondly, my lord, in paragraph 33, my lord, kindly see paragraph 33 of the impugned order. Although the observation in the order of my lord, para 36, my lord, I'm sorry, my lord, subject to correction, para 36. It is to be noted that although Article 33 use the expression shall not end before, leaving it open for the tenure to be 20 years or more, the Indian Parliament in its wisdom has chosen to strictly apply the said article by fixing the term of a patent to a period of 20 years from filing. Such implementation is perfectly within the legislative competence of the Parliament and in consonance with the TRIPS agreement as well. Thus, there is no scope of interference. My lord, I am partly disagree with the proposition, because my lord, herein I have not got the equal protection before the law. When I have applied, my lord, I have paid the renewal fees for the entire period, and they have delayed in grant. And in 2012, I have got the patent. In 2014, I have brought the infringement suit. And now it has been getting fruits, my lord. I have received 51 crore as a royalty, and government is taking 18 crore GST in this patent. And when it comes to give the services, government wants tax in American scale and give services like Burundi, my lords. So government has to stand by with the patent holder and has to legislate something which can be fruitful for the inventions, and so that more patents can be applied in India.
No, you just go through, which are relevant findings of the
My
law.
lord.
Yes.
My lord, Article 33, my lord, mandates substantive 20-year tenure, which I have not got. From the date of filing, it mandates, it records, and I have got 13-year enjoyable tenure. My lord, the government has failed in their counter affidavit to show that what like privileges I have got during the I have applied for an application for patent. Government has not showed in their counter affidavit. They have not denied any allegations. They have only denied on the technical points. Affidavit of opposition has been filed. Written notes of submissions has been filed before the writ court. The writ court has not considered that why there is an administrative delay of 7 years and what like privileges we have got. My lord, I have some judgments and discussions with regard to this.
Administrative delay.
My lord, this issue was discussed in the Delhi High Court also. Sir. Sir.
দুটো ক্যারেক্টার
Sir. Sir, এই দুটো My lord, in all these applications,
patent act to consider this.
My lords, in all these judgments, my lord, orders, my lord, there is no finding with regard to the what kind of like privileges which government is granting during the process of granting the patent. The Delhi High Court has formed a committee of Secretary IPP and called for a report from the expert committee that what kind of like privileges and why that there is a delay of granting the patent, because there are numerous writ petitions pending against the patent office for delay in granting the patent. And my lord, in this year only 300 writ petitions has been disposed of by this court. My lord, the thing is that there is a substantive delay, killing of the tenure by the patent office. There is an administrative delay. There is no answer with regard to this in the statute books.
That you have said, but still I am not clear as to how you say section 53 is ultra virus.
My lord, there are two prefaces used in the legislature, my lord. Every law which has been legislated, my lord, this judgment has been reported by Honorable Supreme Court, my lord. Every law which has been legislated by the legislature has to be given prospective effect unless there is written that it will be given as a retrospective effect.
No, you please.
My lord, kindly see section 53.
No, straight away you refer to the finding of the learned single judge on
Yes.
this argument.
My lords.
Then you can refer to the other points. First, you show the paragraph
My lords.
where your argument was recorded,
My lords.
your submission.
My lord, may I take your lordship to my written notes of argument?
No, from the learned
Yes,
single
sir.
bench's order,
My lords.
learned judge's order.
My lord, page number 288, my lords.
288.
My lord, the primary ground of challenge is that as per section 53(1), the term of every patent granted after commencement of the Patents Amendment Act 2002 and the term of every patent which has not expired and has not ceased to have effect on the date of such commencement shall be 20 years from date of filing of the application of the patent. It is argued that as per provision of the Patent Act, the patent confers right on the patentee to institute litigation for infringement and have all other rights of patent only from the date of grant of patent. My lord, it was my submission before the learned single judge. Section 11A, introduced by 2002 amendment with effect from May 20, 2003 under subsection 7 thereof, provides that on and from date of publication of the application for patent and until the date of grant of patent, the application shall have the like privileges and rights as if a patent for invention had been granted on the date of publication of the application. My lord, this was my submission also before the...
Read.
The provision thereto says that applicant shall not be entitled to institute any proceedings for infringement until the patent has been granted. The petitioner number 1 appearing in person submits that as full rights conferred by a patent commence only from grant thereof, and certain limited rights are conferred on the date of publication. The stipulation in section 53 that term of patent commences from the date of application of the patent is inherently contradictory to the rest of the statute. It is argued that patentee does not enjoy the rights of the patent from the date of application till its publication at all, whereas other rights apart from the right to institute proceeding for infringement are conferred between and the date and publication and grant of patent. Hence, it is unreasonable that term of a patent is to be counted from the date of application, whereas during the period between application and publication only limited rights are conferred and full rights are conferred only upon grant. The interplay between section 53 and 11A of the Act ensures that patentee loses valuable time between the date of the application and the grant. It is thus contended that period between application and grant of the patent ought not to be counted within the term of a patent. Since the said integrum is not only practical benefit of to the patentee insofar as the assertion of the rights on the basis of the patent is concerned. The 20-year tenure of the patent ought to commence from the date of its grant or at least publication, it is argued. The petitioners argue that in a previous writ, the petitioner challenge to the expiry of patent was turned down on the ground that as per existing law, same had to be counted from the date of application. Hence, the virus of the statute was not decided. Moreover, in the review against the said order, leave was granted by the court to the petitioner to prefer a challenge to the virus of section 53 by observing that dismissal of the review would not debar such challenge. Thus, present challenge is not debarred by the principles of res judicata. Thirdly, it is argued that petitioner have not occasioned delay in preferring the present writ petition since the term of a patent has not yet expired. Learned counsel appearing for the respondent authorities argued that writ petition is barred by delay if a challenge was to be preferred by the petitioner. Same had to be done at the juncture when application was made, at least before the patent was granted. Having not done so and enjoyed the fruits of the patent till now, the petitioner cannot now come up on a verge of expiry of a tenure of the patent and challenge the virus of the statute, hereby seeking extend the tenure. Learned counsel argued that petitioner number 1, who was the sole petitioner, then before the addition of petitioner number 2, had no locus standi to prefer the writ petition in view of the patent having been assigned in favor of petitioner number 2. Although arguments were initially advanced by both the parties on such issue, same has been subsequently rendered academic in view of the application filed by petitioner for addition of petitioner number 2 as assignee and writ petition being allowed. Thus, such question of locus standi need not to be gone into any further. The next argument advanced on behalf of the respondent is that section 11A and 53 of the Patent Act are independent on each other, being applicable at different stages. As such, there cannot be any comparison between the two. It is argued that section 11A7 has introduced certain additional though limited rights to an applicant, which cannot be a ground for challenging the virus of section 53. Learned counsel for the respondent contends that 11A7 was introduced subsequently in terms of TRIPS agreement, which cast an international obligation on India, which is a signatory thereto, to make its law compliant with international laws. Article 33 of the said agreement provides that period of 20 years in respect of the term of patent, term of protection shall be counted from date of filing. It is next argued that section 53 comes into play after right of an applicant is crystallized and there is no doubt regarding the innovation of the applicant. My lord, in this matter, crystallization happened in the year 2014 after publication, after 1 year of publication. It has been declared in Wobbens LOI judgment by Supreme Court. On other hand, section 11A7 operates in integrum before the patent is granted, thus two operate at different stages. Paragraph 16 note. Learned counsel for the respondent argues that Parliament in its wisdom amended section 11, which cannot be challenged since there is no arbitrariness or unreasonableness behind it. The provision of section 11A and section 53, it is argued, propound the correct proposition of law in consonance with the purpose and object sought to be achieved by the statute. No patentee, it is contended, loses any time, as the period of patent is 20 years from date of application. After being granted full rights under section 53, patentee cannot rely on section 11A7. Section 53, it is argued, cannot be interpreted from prism of 11A7, as Section 53 comes into operation upon culmination of right and when finality is derived. The right of the patentee as defined under Section 48 of the patent comes into operation from the date of application, and patentee is entitled to seek all damages on account of infringements of a right from the date of application of the patent. The stipulation of the period of 20 years from the date of commencement falls within the legislative domain of the parliament, which is in best interest of the public at large. Learned counsel for the respondent authority next argued this is a second attempt on behalf of the petitioner to seek extension of their patent, which was previously turned down by the writ court. It is argued that mere observation by court while dismissing a petitioner review that the said decision would not preclude the petitioner from challenging the virus of Section 53 does not confer any right on the petitioner to do so. It is argued that the issue is thus barred by principles of res judicata. Although two judgments on locus standi were cited by learned counsel for respondent authorities, those are not being taken into consideration in view of the issue of the locus standi being resolved by impleadment of petitioner number 2, who is the assignee of the patent, as a co-petitioner along with the petitioner number 1. The first ground of challenge thus is delay in preferring the present challenge against the virus of Section 53. The plaint of such argument is that petitioner continued to enjoy the fruits of the patent throughout its tenure and ought to have preferred challenge if aggrieved contemporaneously within publication of the patent. Within publication, 27 admission. However, the challenge to the virus of the section stands on a higher footing than a challenge to executive action taken in terms of thereof. That apart, the cause of action for such challenge is continuing cause of action in view of the term of a patent of the petitioner having not expired. Since Section 53 fixes the tenure of patent at 20 years from the date of application until and unless the term expired, it cannot be said petitioner have lost the right to challenge virus of the section fixing such tenure. The challenge of the petitioner is not against 11A7 but to Section 53, which stipulates term as a 20 years from date of application. Such period having not yet expired, it cannot be said that writ petition is bad on the ground of delay. The second issue is that res judicata. Insofar as previous writ was concerned, the judgment and order rendered therein was on very premise of existing sections of the Patent Act 1970. It was observed inter alia that in view of the statute providing as it does, there was no scope for extension of the petitioner's patent term. The present challenge, however, is to the virus of the Section 53 itself, insofar as it stipulates as a starting point of the term of a patent from the date of publication for it, as opposed to the previous challenge, which was on very premise of the statute. The present challenge assails the virus of the relevant provision of the statute itself, and thus cannot be said to be confined to the section. Hence, the cause of action of the present challenge can be said to have ripened only after the previous dismissal on the basis of very same section, which has now been assailed on the ground of virus. Although the observation in the order of review to the effect that petitioner was not precluded from challenging the virus of Section 53 does not by itself confer any right to so challenge. Such right is to be curbed by previous dismissal of the earlier writ petition of the petitioner. Thus, it cannot be said that the present writ petition is barred by principles of res judicata. Coming to the merits of the challenge, India entered into the agreement on trade-related aspects of international property rights, in brief TRIPS agreement. The said agreement was Annexure 1C to the Marrakesh Agreement, established the World Trade Organization, signed on April 15, 1994. Same was given effect to on and from January 1, 1995. Thus, the said agreement is binding on India. Article 33 of the TRIPS agreement provides that the terms of the patent available shall not end before expiration of a period of 20 years counted from filing date. It is to be noted that although Article 33 used the expression shall not end before, leaving it open for the tenure to be 20 years or more, the Indian Parliament in its wisdom has chosen to strictly apply the said article by fixing the term of a patent to a period of 20 years from filing. Such implementation is perfectly within the legislative competence of the Parliament and in consonance with the TRIPS agreement as well. Thus, there is no scope of interference by the court on such count. A salient feature in the present case is that Section 53 of the Act 1970, as it stands now after amendment of 2002, with effect from May 20, 2003, it is not mutually exclusive or inherently contradictory with Section 11A of the Act. Section 11A(7) confers certain additional privileges on applicant for a patent in the interim between the filing of the application and publication. During such period, 11A(7) has introduced a legal fiction that applicants shall have the like privileges and right as if a patent for the invention had been granted on the date of publication of the application. The only rider is that applicants shall not be entitled to introduce any proceeding for infringement until the patent has been granted. Such right have been conferred as additional right over and above that which were given to the petitioner originally before the introduction of the said provision. The principle laid down in Nasima Naki versus Toddy Tea Company Limited and others, reported in AIR, is applicable in the present case. It is possible to eclipse general law by according protection to a particular class of person under any statute. The statute as it originally stood conferred no additional right on an applicant for a period from a date of publication till grant of patent, but equated the period between date of application and publication on one hand and date of publication and grant on other hand. Such conferment of additional right on publication, which are limited in nature, inasmuch as no litigation for infringement can be instituted, is entirely within the domain of legislative discretion. It has to be remembered that legislature is comprised of elected representatives of the citizen, whereas the courts are not. Thus, legislative wisdom cannot be readily interfered by the court merely because a different perspective is in the opinion of the court possible. The stand of interference with legislation stands on much higher footing of constitutionality than administrative action. Since the starting point of such adjudication is a presumption of constitutionality of a statute, the court's notion of unreasonableness cannot be sufficient ground for holding a statute to be ultra vires. In the domain of legislation, the wisdom of parliament has primacy and cannot be substituted by court's perception. Since the legislature in its wisdom has decided to confer certain additional limited rights on an applicant from the date of publication till grant of probate, my lord, it has to be patent, typing mistake. Probate by introduction of 11A, such conferment of limited rights ipso facto cannot be a ground for demanding further rights from the date of application. Paragraph 41. The three stages of the patent operate in different
Yes.
three spheres. The first stage is that between the date of filing of the application and date of publication, at best, the applicant gets a preference in consideration of the application over subsequent applicants during the stage between the filing of application and publication of the same. Moreover, upon the grant of probate, the right of
This will be also not patent.
patent, it is a typographical mistake. The right of the petitioner relate back to date of application in terms of Section 53 of the Patent Act, thus entitling the patentee to sue the infringement even for a period between application and the grant.
Yes.
An analogy can be drawn to the registration of document under Registration Act, where the registration of a document, the document takes effect retrospectively from the date of execution. Similarly, patents when granted relate back to the date of application. The second stage is that between publication and actual grant of patent, during which period pursuant to Section 11A(7) of the Patent Act, applicant enjoys the like rights and privileges as patentee except for a right to institute any proceeding for infringement, for which patentee still have to wait till the grant of patent, after which it relates back to the second stage as well. The third stage is from grant of patent to expiry of its term. During such period, patentee enjoys full rights and privileges conferred under the Patent Act 1970, including the right to sue for infringement. The said gradation was intended by the Parliament, and there being no patent arbitrariness in the same, such discretion cannot be interfered with a judicial review. A careful perusal of the scheme of the Patent Act as reflected in Section 45 and 53 shows that date of patent in subsection 1 and Section 45 akin to Section 53(1) is the date on which application for patent was filed. There is no contradiction between Section 45 and 53 as both contemplate, in consonant with each other, that the date of commencement of patent shall be the date of application and term of patent is 20 years from date of filing of application. Since TRIPS agreement binds our country as a signatory thereto, the introduction of 20-year term, which was in tune with the same. Exploring the issue further, prior to its amendment by 2002 Amendment Act with effect from May 20, 2003, Section 53(1) provided two category of term of patent under subsection A, subclause A, in respect of an invention claiming method or process or manufacture or substance where the substance is intended for use or is capable of being used as a food or as a medicine or drug. The patent was for 5 years and a date of sealing of the patent or 7 years from the date of patent, whichever period was shorter. Under clause B of the unamended subsection 1 of the section 53, in respect of any other invention, patent would be for 14 years from date of patent. The said pre-amendment regime has been altered by 2002 amendment, granting uniform patent right to all patentee for 20 years from date of application. In fact, present 20-year tenure is enlargement of previous term as per unamended section 53, which provided three categories of patent for 5 years, 7 years, 14 years retrospectively from the point of commencement as stipulated therein. Thus, from perspective of the patentee, the amended section 53 is an improvement in as much as the term of a patent has been increased substantially in line with TRIPS agreement. Hence, there cannot be found any irrationality in the legislature in its discretion, having extended the term of a patent uniformly for all types of patent to 20 years from date of application, while on other hand, conferring certain limited additional right to an applicant for a patent from date of publication to grant of patent under section 11A7. There is thus no conflict between two sections at all. We also have to keep in mind that patent is not fundamental right granted by the Constitution, but one conferred by statute. As such, legislature in its wisdom can selectively confer certain rights from different point at time at different stages of process of grant of patent. The gradation of the stages and associated rights for each stage is not unreasonably discriminatory, thus fulfilling the test of Article 14 and constitutional viability in general. Over and above, the amended provision of Section 53 are not entirely unreasonable, as right of an applicant freezes from the date of application, and he gets priority of consideration over subsequent applicants even before the patent is published or granted. Moreover, petitioner has a right under subsection 2 of 11A7 to request the controller to publish his or her application at any time before expiry of period prescribed under subsection 1 and subject to provision of subsection 3 of the said section, upon which controller shall publish such application as soon as possible. Even otherwise, outer limit for publication and grant of patent has been stipulated under chapter 4 of the Patent Rule 2003. In a scheme of the thing discussed above, this court does not find any discrepancy or inherent contradiction in section 53 vis-a-vis 11A of the Patent Act. Thus, no ground has been made out by the petitioner to strike down the section 53 or any part thereof on the ground of ultra-virus and constitutionality of the said section. As discussed above, it is itself protection of the said provision from being so struck down. In such view of the matter, writ petition failed. Accordingly, WPA is dismissed on contest by holding section 53 is intra-virus to the Constitution. My lord, this was the finding. My lord, there is four contradictions in this judgment, my lord. My lord, one is the present fact is not considered. What is the present fact involved in the writ petition? I am the affected person. I am the patentee. I am holding a patent right, and I have been granted patent in the year 2012. My lord, there is an admission that I will get a like privileges, but no like privileges has been explained. What kind of like privileges I will get? They will only.
Thing is, of course, the learned judges also said there are three stages.
My lord.
Yes.
One, you make an application, and pre-grant publication is effected. In the light of section 11A7, which was introduced in 2005, you will entitled to some like privileges. What is like privileges?
Yes.
It's up to the patentee to state. Then after the patent is examined and publication is effected, a grant is made and a post-grant publication is effected. The only thing which is barred under section 11A7 is that you cannot maintain a suit for infringement.
Yes.
So therefore, nothing prevents you from exploiting the patent on and from the date of application. You read 11A7 once more.
My lord, there is one more discussion has not been recorded by the honorable judge. My lord, there are two classes of
You are trying
licensing.
to interpolate 11A7 to 53.
Yes.
Correct? So therefore, yours is a very reasonable, like administrative delay of 12 years. Your valuable right is lost. But the contention of the respondent, which was accepted by the learned single judge, is that this 11A7 gives you certain
Privileges,
privileges.
except filing of suit. All privileges.
On and from the date of publication of the application for patent, pre-grant publication, and until the date of grant in respect of such application, 2005. You filed it in 2005. The applicant shall have like privileges and rights as if a patent for invention had been granted on the date of publication of the application. This is a right given to you as if a patent has been granted for the invention. What is prohibited is, provided the applicant shall not be entitled to institute any proceedings for infringement until the patent is granted. So you can exploit the patent. You can probably enter into agreements with the patent, etc., with third parties. Only thing is, suppose somebody copies your patent, you can't maintain a suit for infringement, which can be done only after the grant is. That is the only provision.
My lord,
How do you see section 11 appears in chapter 4?
my lord, my humble submission, I most respectfully agree with this proposition, but there is one flaw, my lord, which has not been recorded by the honorable single judge. My lord, if I am not a manufacturer, if I am only the licensee, there is a distinction between a manufacturer and licensee, which was not taken into consideration by the honorable single judge. If I am the manufacturer,
No,
I can exploit the patent, my lord.
But how
most
do you
humbly.
interpolate a provision which is relating to publication and examination of patent under chapter 4 with regard to grant of patents and rights conferred under chapter 8?
My
Both operate in different
both
ways.
operate in different ways, my lord.
And guidelines have been framed. Justice Pratibha Singh's judgment is there, guidelines are there. They have allowed both the petitions. They directed them to re-examine, etc. So this is essentially a missionary provision, chapter 4, as to how the publication and examination of an application has to be done. Chapter 8 deals with the grant of patent and the right conferred on the patentee. So both operate in two different fields.
My lord, be that as it may, for argument's sake, my lord, my most humble submission is that Article 36 mandates 20-year substantive tenure. My lord, that was recorded in the order that 20-year tenure has to be given to the applicant. That is mandated, and that is an international obligation binding upon the country. That was also recorded. My lord,
Where you failed in the earlier petition,
my lord,
you failed.
the honorable single judge has not taken into consideration 3 or 4 facts. That's why the writ has been failed, my lord.
All right. First is facts not considered.
My lord, the first fact is that
What are
I am not a
grounds?
my lord.
Be crisp. We are giving you so much of time. Be crisp.
My,
1 hour you have been arguing.
my lord, my lord, I am not a manufacturer. I am a licensee. I do not manufacture as per the Patent Act. If I am the manufacturer, then I can apply for a patent and I can keep on exploiting the patent. If I am the manufacturer, my status is that I am not a manufacturer. I am a licensee. First, so my right will only start on and from date of grant of patent, and that is a statute. Second is that, my lord, the honorable single judge has not mentioned what kind of like privileges has been given to the patentee. Only mention is that you can get a damages on retrospective basis on and from date of grant of patent. You can
like privileges is for the patentee to how the learned judge will. We don't.
My lord, if a legislature is granting something right, it cannot be a vague.
No, as a patentee, you are the inventor. You know what are the privileges you will be able
My
to
lord,
enjoy.
the like privileges, what are the like privileges? The patent is for commercialization. What is the object of the
Where
patent?
is your written notes of argument?
My lords.
Page. We will consider that.
My lords.
Page 278, additional written notes.
My
Just
lords.
by respondent.
My lord, we have filed 2 or 3 written notes, me and my learned friend.
Kindly peruse his writ petition, what case he has made out. And he cannot make a new case before the appellate court.
No, I am not making, sir.
No, his case is only based on 11A7.
Yes.
11A7,
It is administrative function, my lord. Administrative
My
function,
lord.
like privileges he will get. And if nobody knows, my lord, there are other applicants. Until and unless the process is complete, it is not known to the department, my lord, whose patient ultimately will be granted. But all other benefits will get.
My lord, my third ground is that, my third, 2 grounds were noted. Third ground is that, my lord, Article 33, paragraph 36 of the impugned order, wherein Article 33 of the TRIPS agreement has been quoted, wherein the Honorable Single Judge has recorded that there is an obligation of granting substantive 20-year tenure to each and every applicant, and that is an international obligation upon India. So, my lords, Government of India is bound to give 20-year full tenure, full substantive tenure to each and every applicant. So each and every applicant who applies for patent and apply for early publication, I have applied for early publication and my patent was earlier published. So they have to grant me a patent within a stipulated period of time. They don't have a time.
then you should have filed a writ petition.
I have filed a writ petition, Patna.
2005.
My lord, I have filed, and Patna High Court has directed to grant me a patent. Then only they have granted me a patent, or otherwise they are sleeping tight over the issue. This was the conduct of the government. What has happened, my lord? They will delay on their own, and on later stage they will say you have the like privileges. You go and exploit. Why didn't you have exploited? My lord, courts are not unaware of the fact that until and unless grant is there, nobody is going to pay the license fee. The government is trying to show that courts are sitting over the ivory coast and not aware of the factual position. But the thing is that the real proposition is that until and unless I got the patent, final grant, nobody will pay me the license fee. And this thing, India is a sovereign country. India can make its own law. With respect to the TRIPS agreement, by taking into consideration the TRIPS agreement, wherein the mandate was shall not end before, means it is not binding India that
Therefore, the long and short of your argument is Section 53 of the Patent Act is contrary to 11A7.
My lords.
And read with Rule 24 or some Rule 23. That is your argument.
My lords.
That we will consider. Where is your written submission? You tell the page.
My lord, my written submission starts from page number.
Fast follow children.
Respondent.
Subject to correction 208, your lordship.
208. Thank you, sir. 208.
208 to 247.
208
No,
to 247.
247. 208 to 247.
47.
It starts from 208.
208 to 212.
No, in the context it is listed to 47. There may be typing.
Index
Index it is there, Malat. 208.
So the written submission.
My lord is perfect, perhaps right.
Written notes submitted by the petitioner.
Yes.
My lord is
And
perhaps my lord is right.
Your written argument, sir?
Mine. Yes.
Page number, we'll go through that.
My lord, 208.
On where? 278.
278.
This is additional. There before that arakta chilo na. Only your lordship 278.
278.
Status report.
My lord, one more example I will cite. Page number 215.
Yes.
My lord, kindly sees this is a hydrogen patent. Now Indian Railways is adopting. This is my patent, my invention. I have given patent. I have applied in the year 2005, And after the writ court order, I have been granted in the year 2021. Now, what royalty I will get, and my patent is due to expire in May. Then why I will apply for patent in India? Why I will not go to US, where there is a mechanism of getting the patent
Immediately.
within a fixed period of time?
But here also the guidelines provide for.
Yes, my lords.
In
For
fact,
in
Justice,
24
you
in
gave
24
this
months.
judgment.
My lord, the different companies have invested in my venture. Now its fruits are started to come from now onwards. The government of West Bengal is opening a company for collection of royalty. The suit is about to settle. The file is with the chief minister. And now what thing happening? Due to this administrative delay, my patent is get lost, and I will my infringement suit, which is restraining all the states in the country, and we are having 250 licensee.
2012, you could have exploited your patent. It was granted in 12.
My lord, and
in 2025.
My lord, in the year 2014, I have brought the infringement suit, and 2014 till and now, the government of India is taking time in the suit for infringement, and they are contesting, and now its fruition is started to come. My lord, they deliberately delay grant of patent like this. And my wife has applied 3 or 4 patents, and she has not been granted patent till now.
Better you apply outside India. And all are all engineering patents. Both are engineers.
My lord, I am MSc Physics. She is also. In COVID period, we have enrolled as an advocate.
Okay.
First time it was moved by the petitioner's husband, being a patentee. Then it was found, pointed out that he is not the patentee, he has transferred his patent.
So
then, my lord,
she-
application for addition of party.
My lord, 50-50
And another
right
thing,
has
my
been
lord, there
given-
is, I
distributed
find from the
between-
record, my lord, another.
In
Ca-
fact, in this judgment, Procter and Gamble, the learned judge has observed. There's no page. Page para 18 at page 6. The said timelines reflect the intention of the legislature to ensure that no unnecessary delays are caused in the process of grant of patents. Though no specific time period has been prescribed for passing orders after conducting oral hearing, the patent office is expected to pass the same within a reasonable period. Such reasonable period cannot be beyond 3 to 6 months in any case, depending on the complexity of the case. In the present case, a period of 4 years had elapsed after hearing, when the order was passed finally by the patent office, that too after issuing notice under section 8(2) of the Act, for which adequate time for reply was not granted. Therefore, the order is set aside. Patent office change of status, so and so, so and so.
My lord,
not
thousands
the
of
subject
applicants
matter of
we have
challenge.
suffered, my lord. I am not the exceptional case. The issue is that why why China is exceeding applications for patent, and we are not getting the more applications because of these flaws in the law. It can be curbed by the government. If government sits on my proposal,
In the other judgment, they say there are some draft guidelines
my lord,
that has not been published.
that was not published. My lord, it can be solved if government is ready to sit and think, because it is a mere flaw, my lord, nothing else.
You file a 32 petition.
My lord, I have discussed with the secretary. I have met with the secretary. Secretary was saying that we can give you consent on your status quo application, but other applicants will take benefit and file cases. That was the issue. But I have convinced I have submitted before the secretary DIPP that the thing is that this is a interim stage.
And I strongly
My
take
lord,
exception to this
No.
statement, because,
Subject
my
to
lord,
confirmation.
saying
Subject to
that he
that,
has
I
made-
have submitted. He has not consented. He has
Consider
not
the legal issues. All right.
and one other thing, my lord, my junior has found, my lord, another case status with respect to self-same parties, my lord, number. I do not know on what ground this has been filed.
No, this is against the state of West Bengal, sir. This is against the state of West Bengal, not Union of India.
All right. The constitutional validity we will consider.
This is against the
We
state of
have
West Bengal.
heard the appellants appearing in person and the learned senior standing counsel for the respondent. Judgment reserved. Thank you. Next.
नाम दे दीजिए।
My lord, in item number 3 and 4, I appear on behalf of the respondent.
Affidavit of service. Should the appeal is against the
Lookout notice,
Lordship?
lookout circular.
No, this is
Declaration of fraud.
classification of fraud in respect of the loan account in which the petitioner respondent was an director during the period for which the classification was declared. Lordship, may I take your
At only 2 grounds they challenged, no opportunity and
Lordship?
audit report.
Lordship, there are 2 grounds, Lordship. Before the grounds also, Lordship, before I place that, I will just indicate 2-3 pages. That is the show cause notice. The show cause notice is at page 74 of my CAN 1 application. This is the show cause notice. I'm not placing the show cause notice right now in details, Lordship. The reply, Lordship, is at page 78. Page 78 is the reply by the writ petitioner. The only thing I will indicate for the time being is, Lordship, paragraph 5. Paragraph 5, that is at page 79, states that the bank undertook forensic audits for the years 2020 and 22. The first audit was conducted by MS Shumon Kumar Agarwal and Associate Chartered Accountant based on their intimation letter bearing reference number this and this, covering the period between 1/4/2017 to 31/3/2020. Second audit conducted in 2022 was carried out by R. Dokani and Company Chartered Accountants. An intimation letter dated this and this, covering the same period. And once again in 2024, a forensic audit was conducted by S. Jayakrishnan Chartered Accountants for the same period. We presume they have submitted their report to the bank. So the knowledge of the forensic audit was well within the petitioner's knowledge, writ petitioner's knowledge. Now, Lordship will kindly take up the page 178. (178) is the declaration of the account as fraud. We refer to the show cause notice issued by us with our letter date is 27/12/2023 and your response with a letter dated 8/2/2024. We have taken cognizance of your response to a show cause notice, and after due examination of the same, it is concluded that sufficient reasons have not been provided by you to explain the non-adherence to the agreed terms and conditions of the loan documents or irregularities observed in the conduct of your account to the satisfaction of the bank. Accordingly, the bank has decided to classify your loan account as fraud as per the enclosed speaking order. The speaking order is the next few pages, Lordship.
Yes.
Yes. Lordship, may I place the speaking order?
No,
Lordship, I'll place the impugned order. I know what is bothering your Lordship.
no,
about
not
the-
bothering. Has the learned judge gone into the merits of the matter?
No, learned judge has not gone into the merits of the
So
matter.
you
Learned
play-
judge says,
You place the order and
yes,
then
I'll place the order. It is at page 226.
we'll take it from the memo of appeal.
Memo of appeal. Yes. Memo of appeal. Memo of appeal. I'm placing it. It's the same thing in any case. Any case. 26. Lordship, may I please? Lordship, one thing I will indicate that at the time of filing the reply to the show cause notice and even thereafter, there was no representation made on behalf of the petitioner, writ petitioner, that she was not supplied any audit reports. And Lordship, the writ petition has been filed challenging an order passed by the State Bank of India declaring the petitioner's bank account as fraud. The ground for challenge is that personal hearing was not given to the petitioner. The second ground is that the forensic audit report that was relied upon has not been supplied. The petitioner places emphasis on the issue of violation of the principles of natural justice. It is submitted that jurisdiction of this court has been invoked as the principle of odi alteram partem being an essential element of any decision-making process has not followed. It is submitted by the petitioner ceased to be a director of the bank borrower company from 2018 and declaration and NPA was made later. Thus, the bank could not proceed against the petitioner who was neither a whole-time director nor a promoter at the relevant time. It is submitted by Mr. Banerjee, learned senior advocate representing the petitioners, that the Honorable Apex Court and the Honorable High Court had repeatedly held that any document relied on by the bank should be supplied to the borrower, and the borrower must be given an opportunity to explain his defense against the proposed allegations of the lender. Reliance has been placed on a decision of the coordinate bench in the matter of Hemant Kanoria versus State Bank, reported in this and this. Mr. Rai, learned advocate appearing on behalf of State Bank of India, submits that personal hearing was not necessary. He relies on the decision of the Honorable Apex Court passed in miscellaneous application number 810 of 2023, arising out of civil appeal number 7300 of 2022. The miscellaneous application was filed by Union of India for a clarification of the observations made by the Honorable Apex Court in the decision of State Bank of India and others versus Rajesh Kumar Agarwal and others. If your Lordship may permit me to pause here for a minute and indicate that what is the clarification that was sought for in the Rajesh Agarwal's matter. Lordship will kindly take up page 236. It is in the scan application. Lordship, Lordship has found it?
Yes.
Yes. The apprehension which has been expressed by the learned Solicitor General of India is that since the judgment of the Division Bench of the High Court of Telangana dated 10 December 2022 was upheld by the judgment of this court dated 27th March 2023, the judgment of this court may be interpreted in the future to mean that the grant of a personal hearing is mandatory, though it has not been so directed in the conclusions set out in paragraph 81 of the judgment. While upholding the judgment of the High Court of Telangana dated 10th December 2020, the operative directions of this court are those which are summarized in paragraph 81 in section E of the judgment. Lordship, may I now take your Lordship directly to page 296, which is the summary of the directions in paragraph E, paragraph 81E. The directions are the conclusions rather, no opportunity of being heard is required before an FIR is lodged and registered. Classification of an account as fraud not only results in reporting the crime investigating agencies, but also has other penal and civil consequences against the borrower. Debarring borrowers from accessing institutional finance under Clause 8.12.1 of the Master Direction on Fraud results in serious civil consequences for the borrower. Such debarment under Clause 8.12.1 of the Master Direction on Fraud is akin to blacklisting the borrower for being untrustworthy and unworthy of credit. The court has consistently held that an opportunity of hearing ought to be provided before a person is blacklisted. The language, Lordship will kindly mark, is an opportunity of hearing. The application of odi alteram partem cannot be impliedly excluded under the Master Directions on Frauds. In view of the time frame contemplated under the Master Direction of Fraud, as well as the nature and the procedure adopted, it is reasonably practicable for the lender banks to provide an opportunity of hearing to the borrowers before classifying their account as fraud. The principle of natural justice demand that the borrowers must be served a notice, given an opportunity to explain the conclusions of the forensic audit report, and be allowed to represent by banks or JLF before their account is classified as fraud under the Master Direction on Fraud. In addition, The decision classifying the borrower's account as fraudulent must be made by a reasoned order, and since master direction on fraud do not expressly provide for an opportunity of hearing to the borrower before classifying their account as fraud, audi alteram partem has to be read into the provisions of directions to save them from the vice of arbitrariness. So the language which is repeatedly used is the opportunity of hearing. Now, this question was particularly raised that this may be interpreted, and their lordships in their wisdom might have in one line explained that yes, it means personal hearing, but that was not done. It was clarified that it is only the conclusions which are arrived at in paragraph E are the particular directions which are to be followed by the banks in proceeding with the master circular on classification of fraud. Now, if I take your lordship again, once again to the impugned judgment, lordship, this argument has been considered by the learned honorable single judge, and he has come to the finding that lordship, paragraph internal page 8 of the impugned judgment 17. Upon a meaningful reading of the decision in Rajesh Agarwal and another Supra, an order passed in miscellaneous application, this court holds that before declaring an account as fraud, the documents relied upon by the identification committee should be mentioned in a show cause notice and also supplied to the borrower. The borrower should be allowed to represent his case by filing an answer to the show cause notice and also by dealing with documents which the committee proposes to rely upon. The borrower should be allowed to represent his case before the authority by way of a personal hearing, and thereafter the order may be passed with reasons. The reasoning portion, I'm sorry, lordship, it is at paragraph 12. She's given the reason. The Honorable Apex Court held that the principles of natural justice demands that borrower was to be served with notice, given an opportunity to explain the findings in the forensic audit report and to represent their case before the account was classified as fraud under master direction of fraud. In the interpretation of this court, specific directions has been passed with regard to service of notice, opportunity to explain the contents of notice, and to represent. The expression represent implies that person who has filed a reply to show cause should be allowed to represent his case by explaining to the authority why the account should not be declared as fraud. Representation and filing of explanation are two distinct and separate steps prescribed by the Honorable Apex Court. However, the Honorable Apex Court has also clarified such position on the request of the learned Attorney General of India, which is part of the order passed in the miscellaneous application. Mr. Rai's submission that Apex Court had held in miscellaneous application that personal hearing need not be granted to the borrower is not correct. Section E of the judgment is the conclusion arrived at by the Honorable Apex Court after discussing the issues involved. Relevant portion is quoted of Section E is quoted below. Paragraphs 98.5 and 98.6 of the order deal with concluding directions. Honorable Apex Court directed that it would be reasonably practicable for the lender to provide an opportunity of hearing to the borrowers before classifying their account as fraud. Paragraph 98.6 indicates that Honorable Apex Court held the principles of natural justice demanded that the borrowers must be served a notice, given an opportunity to explain the conclusion of the forensic audit report, and be allowed to represent before the bank declares the account as fraud. Honorable Apex Court was of the view that not only should a person be allowed to answer the show cause notice, but the forensic audit report, which is not supplied, should be supplied to the borrower. Even if the borrower was present during such audit, the borrower is allowed to represent his case before the authority concerned. Now, what the Honorable Single Judge has arrived as is that the opportunity of hearing is akin to personal hearing. Lordship, for this, I beg to show a proposition. I don't have a copy. I'll give 1996 or SCC, page 69. Lordship, this at paragraph 1, Lordship, the question was framed that the appeal has been filed on behalf of the Union of India against the judgment of a full bench of the Delhi High Court, holding that an oral hearing had to be given to the respondent by the appellate authority before taking a decision under third proviso of subsection 1 of section 4M of the Imports and Exports Act 1947. Now, Lordship, may I take your Lordship to paragraph 5, which is at page 74 of the judgment. Lordship has found paragraph 5.
Yes.
Lordship, I'm relying on the from the in that connection. It need not be pointed out. It need not be pointed out that under different situations and conditions, the requirement of compliance of the principle of natural justice vary. The courts cannot insist that under all circumstances and under different statutory provisions, personal hearings have to be afforded to the persons concerned. If this principle of affording personal hearing is extended whenever statutory authorities are vested with the power to exercise discretion in connection with statutory appeals, it shall lead to chaotic conditions. Many statutory appeals and applications are disposed of by the competent authorities who have been vested with powers to dispose of the same. Such authorities, which shall be deemed to be quasi-judicial authorities, are expected to apply their judicial mind over grievances made by appellants or applicants concerned, but it cannot be held that before dismissing such appeals or applications, in all events, the quasi-judicial authorities must hear the appellants or the applicants as the case may be. When principles of natural justice require an opportunity to be heard before an adverse order is passed or any appeal on application, it does not in all circumstances mean a personal hearing. May I pause here for a moment, Lordship? So the Honorable Supreme Court has in this judgment, which is still holds good, and I'll place a subsequent judgment also. So there is a distinction between the opportunity to be heard and that of a personal hearing. And that was also the clarification which was intended by the lordships in the miscellaneous application, which is filed to seek that clarification. The requirement is complied with by affording an opportunity to the person concerned to present his case before such quasi-judicial authority who is expected to apply his judicial mind to the issues involved. Lordship, this is on the proposition of personal hearing, Lordship. My most respectful submission is the opportunity of hearing and personal hearing are not synonymous, and that has been clarified in the miscellaneous application. Now, with respect to the other part of the order, Lordship, the supply or providing the forensic audit report. Lordship, my first submission is on estoppel, that she had already submitted her response. In that response, she had indicated that there were some forensic audits undertaken. So she was aware. Lordship will kindly take up the Lordship will kindly take up paragraph 9 of the impugned judgment at internal page 4.
Yes.
Having heard the learned advocates for the respective parties, this court finds that admittedly a hearing was not given to the petitioner. Secondly, order of the bank indicates that the bank had relied on some prior decision of the ICICI Bank and Axis Bank and 2 forensic audit reports. The order of the Committee for Identification of the Account as Fraud and the proceedings of the meeting indicate that weightage was given to the decision of ICICI Bank and Axis Bank. The banks had declared the account as fraud. Further reliance has been placed on the forensic audit report of Shumar Kumar Agarwal and Associates dated November 2, 2020 and R. Dokani and Company dated December 24, 2022, which were not supplied to the petitioner. The show cause notice which was issued to the petitioner and to which the petitioner replied did not contain any reference to the decisions of ICICI Bank and the Axis Bank. No reference was made to the 2 forensic audit reports. Now, most respectfully, Lordship, if I take your Lordship once again to the declaration of fraud by the bank, that is at page 178.
Yes.
I'm directly placing page 179. It is just a note that the account has been declared as fraud by ICICI Bank on 15/3/2021 and Axis Bank on 24/12/2020. Full stop. Proposal was put forth to the Identification Committee on 17/12/2022. FIC in its meeting dated 24/1/2023 identified the account as red flag account. This is the only portion where reference has been made to the classification of the account as fraud by the ICICI Bank and the Axis Bank. No reliance, most respectfully, was per se placed on this report, or that the classification was based on this. The classification of the account as fraud was particularly based on the tabular form which is appearing from the next page. Now, based on the forensics report, forensic audit reports of Suman Kumar Agarwal and Associates dated this and this, and R. Dokania and Company dated this and this, proposal was placed before the FIC of the bank in its meeting dated 2/12/2023. FIC declared the account as having prima facie evidence of fraud and decided to issue show cause notice to the borrowers, directors of the company on account of the following reasons. Disposal, Lordship, this argument was also made before the Honorable Single Judge that from the material which was on record or available before the Honorable Single Judge, the Honorable Single could not have held that the declaration was bad. So this submission was made, that is recorded in the impugned order. Disposal of removal of pledged hypothecated mortgage machinery, assets financed by the bank, charged to the bank without knowledge or consent of the bank, and not deposited or routed the sale proceeds in the accounts maintained with the bank or branch and misutilized the proceeds. Availing of unauthorized credit facilities by overstating assets, sale income and profit disproportionately by submitting their fabricated, forged, manipulated financial statements, income tax, GST and other returns. Substantial related party transactions with interconnected companies or entities not at arm's length or unrelated transactions. Show cause notice was sent to the borrower on 27/12/23. Reply from Amit Iron Private Limited, Shri Amit Agarwal, Srimati Chanda Agarwal, Srimati Shweta Agarwal. Viday letters dated 8/2/2024 were received in response to our show cause notice. Committee has gone through the representations of the company and of all the other borrower guarantors dated 8/2/24 carefully, Viday which the borrower guarantor director made their submissions and averments in response to the show cause notice dated 27/12/23. Committee has also perused various records relied upon in directing and identifying the suspicious transactions relating to apprehension of fraud. The finding of the committee upon perusal of various records and reasons for disagreement with the representation made by the borrower are as under. Thereafter, it has been categorically dealt with. If your lordship permits me, I can place the incidents of fraud, but I will prefer to get back to the point. I know what is whether that the audited financial audits were supplied to the borrower or not. Lordship, regarding this, I have a twofold submission. One, I have stated that they were stopped from raising this point because all along when the proceedings was being conducted, this point was never raised before them. And the second point, Lordship, which I will beg to indicate is that even if the audited report was not supplied, it is not a case that there was complete violation of the principle of natural justice. Possibly it was that the opportunity granted to the borrower was not adequate. Possibly it is that Lordship will find reference in the Honorable Single Court's judgment to the judgment of, this was placed by the writ petitioner, that is the ECL versus, it is at internal page 5. ECL versus B. Karunakar, reported in 1993, 4 SCC 727. Lordship, this was the judgment where, may I hand over copies? Now, Lordship, this judgment at paragraphs 25, 26 and 28 upheld that the inquiry officer's report was required to be supplied to the delinquent officer.
Paragraph.
This is 25, 26, and 28,
Hmm.
Lordship, possibly.
Correct.
Yes. Now, Lordship, there was one more issue or question which was framed, that was at page 757 of the judgment. Lordship, the issues, questions were framed. Lordship will find from first 740, the question 5. What is the effect of non-furnishing of report on the order of punishment, and what relief should be granted to the employee in such cases? This was the issue which was framed in this judgment.
Yes.
This judgment was relied on by the writ petitioner. Now, Lordship will kindly take up page 757, Roman clause 5. The next question to be answered is, what is the effect on the order of punishment when the report of the inquiry officer is not furnished to the employee, and what relief should be granted to him in such cases? The answer to this question has to be relative to the punishment awarded when an employee is dismissed or removed from service and inquiry is set aside because the report is not furnished to him. In some cases, the non-furnishing of the report may have prejudiced him gravely, while in other cases, it may have made no difference to the ultimate punishment awarded to him. Hence, to direct the reinstatement of the employee with back wages in all cases is to reduce the rules of justice to a mechanical ritual. The theory of reasonable opportunity and principles of natural justice have been evolved to uphold the rule of law and to assist the individual to vindicate his just rights. They are not incantations to be invoked nor rites to be performed on all and sundry occasions. Whether in fact prejudice has been caused to the employee or not on account of the denial to him of the report has to be considered on the facts and circumstances of each case, where therefore, even after furnishing of the report, no different consequence would have followed. It would be a perversion of justice to permit the employee to resume duty and to get all the consequential benefits. It amounts to rewarding the dishonest and the guilty, and thus to stretching the concept of justice to illogical and exarpating limits. It amounts to an unnatural expansion of natural justice, which in itself is antithetical to justice. Hence, in all cases where the inquiry officer's report is not furnished to the delinquent employee in disciplinary proceedings, the courts and tribunals should cause the copy of the report to be furnished to the aggrieved employee if he has not already secured it before coming to the court or tribunal, and give the employee an opportunity to show how his or her case was prejudiced because of non-supply of the report. If after hearing the parties, the court or tribunal comes to the conclusion that the non-supply of the report would have made no difference to the ultimate findings and the punishment given, the court or tribunal should not interfere with the order of punishment. The court or tribunal should not mechanically set aside the order of punishment on the ground that the report was not furnished and is regrettably being done at present. The court should avoid resorting to shortcuts, since it is the courts or tribunals which will apply their judicial mind to the question and give their reasons for setting aside or not setting aside the order of punishment, and not any internal appellate or revisional authority, there would be neither a breach of the principles of natural justice nor a denial of reasonable opportunity. It is only if the court or tribunal finds that the furnishing of the report would have made a difference to the result in the case that it should set aside the order of punishment, where after following the above procedure, the court or tribunal set aside the order of punishment, the proper relief that should be granted is to direct reinstatement of the employee with liberty to the authority or management to proceed with the inquiry by placing the employee under suspension and continuing the inquiry from the stage of furnishing him with the report. The question employee would be whether the employee would be entitled to back wages and other benefits from the date of dismissal to the date not placing this. Lordship, so what I beseech your Lordship to indicate is that even if the Honorable Single Judge was dissatisfied that the report was not the audit report was not supplied, the declaration should not have been set aside at that go. Instead, the bank should have been directed to file or serve and as well as file the audited financial reports before this honorable court, and only if the honorable court would come to the finding that on placing reliance or of the financial audit reports, if the honorable court would have found that the party should be relegated back and that the outcome, what was the final outcome or declaration of fraud was erroneous, then only they should have been relegated back. Lordship, this proposition holds good in this judgment. Lordship, I'm referring to one more judgment, 2005, 1 SCC 13. Lordship, paragraphs 30 and 31. Lordship, 30 I'm not placing because I have already placed this case of Union of India versus Jesus Sales Corporation, where I have indicated that personal hearing and opportunity of hearing are not akin. Now, Lordship, may I please paragraph 31. Mr. Salvi invited our attention to paragraph 17 of the judgment of State Bank of Patiala. This is not relevant. He drew our attention to S.L. Kapoor versus Jagmohan and Managing Director ECIL versus B. Karunakar in SCC paras 25, 26 and 28. The decisions relied on and cited above make one thing clear, namely, principles of natural justice cannot be reduced to any hard and fast formula. And as said in Russell versus Duke of Norfolk, these principles cannot be put in a straitjacket. Their applicability depends upon the context and the facts and circumstances of each case. The objective is to ensure a fair hearing, a fair deal to a person whose rights are going to be affected. In our opinion, the approach and the test adopted in Karunakar case should govern all cases where the complaint is not that there was no hearing, no notice, no opportunity, and no hearing, but one of not affording a proper hearing, that is adequate or a full hearing, or violation of a procedural rule or requirement governing the inquiry. So this is the rule which has been held to be the good law, that if the honorable court is satisfied that the outcome of the decision would be different, then only the parties should have been relegated back, and not on the mere technicality, the entire order of the declaration of fraud should not have been set aside.
Yes, sir.
My lord's first submission, which has not been perhaps highlighted, our clients have not been given any blanket protection. Lordship will see that in the impugned order itself, all that had been done is that the report of the identification committee has been set aside for want of supplying these documents. They have been asked to supply these documents to me, and thereafter I'm supposed to be granted an opportunity of hearing, and then the procedure prescribed by law will take its course. No blanket protection has been granted. My lords, the first question which arises is, why this hide and seek? What is the problem? Is there anything inconvenient in those documents that you simply do not want to give me the documents on the basis of which you have started these proceedings and have declared me as fraud? Now, Lordship, one difference, a distinguishing feature in all the judgments which have been cited by my learned friend, the new judgments which have not been considered in the impugned judgment, my lord, the distinguishing feature is, in case of declaration of fraud, there is a severe penal consequence. A severe penal consequence. In fact, Lordships will find it has been held by the Honorable Supreme Court in Rajesh Agarwal's case that it is akin to civil death. Which is why, Lordship, it is not a question of me getting an opportunity or me asking for an opportunity. My lord, the judgment in Rajesh Agarwal's case is unambiguous and very clear. It expressly says it is not for me to ask, it is for you to give. When you are issuing me with a show cause notice, you have to give me the documents on the basis of which the show cause notice has been issued. If the show cause notice is not accompanied by the forensic audit report, Lordship, first of all, how am I supposed to know what conclusion has been reached in the audit report? Which is why it is incumbent on the authority or the bank to give me the report. I'm to be granted an opportunity to consider it and thereafter make any submissions. The next point urged is waiver. Lordship, with the deepest of respect, this argument of waiver is unheard of in law when it comes to fundamental rights. Lordship will again see in Rajesh Agarwal's case, the opportunity of hearing has been read into the master directions on frauds because of violation of Article 14. It is something which is to be granted to me because the Constitution gives me that right, and it is a fundamental right. And Lordship knows, my Lord, from 1959 in CIT versus Bashishwarnath, it's been the consistent position of law. Fundamental rights cannot be waived. Even if I wanted to waive my fundamental right, I cannot. And in any case, the question does not arise because it is not for me to ask. It is for you to give me the documents. And if the procedure is transparent, there is no problem. If the audit report says, has arrived at a finding, truly, there is fraudulent activity, Lordship, the law will take its course. Why the hide and seek? Why this attempt to deny me a look at these documents? Is there anything to hide? That is the question, Lordship, I asked myself. My Lord, may I place a few paragraphs from the impugned judgment? And before that, Lordship, may I explain the other judgments relating to Exports Act, which was placed by my learned friend in Jesus Sales Corporation, my Lord. First, this concerned an appeal provision. Lordship knows that filing of an original proceeding and filing of an appeal, they stand on a different footing. I have no real vested right unless it is granted to me under law. It merely concerned the question of deposit where already a relaxation had been granted. In that context, the question of opportunity of hearing, personal hearing, and opportunity of being heard was raised. My Lord, respectfully, I submit this issue does not even arise in our case because, again, in Rajesh Agarwal's case, it has been held unambiguously. What is to be granted is a hearing. First, audit report has to be given to me, the documents on the basis on which you have commenced the fraud proceedings. Then the question of hearing comes. In this case, Lordship, what has happened is the procedure falls at the first step. It is your constitutional obligation to give me the report, thereafter give me a hearing. This confusion of opportunity of being heard and of personal hearing does not arise. And Lordship, these judgments, they concern different statutes. In my respectful submission, we are here concerned with the RBI Master Circular on frauds. There is a definitive pronouncement by the Honorable Supreme Court on this particular master directions, and whatever is stated, whether it be the requirement of natural justice, whether it is a straitjacket formula, these questions do not arise because in the facts and circumstances of any proceeding relating to this particular circular, it is the Honorable Supreme Court's judgment in Rajesh Agarwal alone which will govern the proceedings. Therefore, if it has been held in Rajesh Agarwal's case that you have to give me the audit report, thereafter, you have to give me an opportunity of hearing, not opportunity of being heard, but hearing, then the question of taking a further decision arises. In this case, Lordship, I would have understood my learned friend's submissions if the entire proceedings had been set aside. They have not been set aside. We had sought setting aside of the entire proceeding, but Lordship, we cannot shirk away. There are two audit reports. There appears to be a finding. There is a proceeding. We cannot shirk away from that. We cannot avoid it. Lordship, the Honorable Single Judge merely set back the clock to a particular stage when it comes to the identification committee. Simply supply me with the report and thereafter I get a chance of being heard. And then again, if the same conclusion is to be reached, it will be reached, Lordship. We'll have our recourse in law, whatever they may be. And lastly, Lordship, my learned friend submitted that in some cases, supplying me with the report would have made no difference to the conclusion. My lord, that is very presumptuous.
That was in a service dispute.
That's a service dispute. I do not know what is the conclusion in the audit report. Certain inferences drawn from the audit report have been set out in the show cause notice, which has been placed by my learned friend. Now, how do I, if unless I am given the opportunity of looking at the primary document, how do I know whether any difference would be made or not? And one last submission, my lord. Lordship will see that page 179 was placed by my learned friend, on the basis of which the declaration of fraud was made. Well, it says the account has been declared as fraud by ICICI Bank and Axis Bank. Proposal was put to identification committee. Now, Lordship will see that this procedure gets commenced first because they are relying on the decision of.
You are aware of this?
Lordship, that is what I am submitting. From this document, Lordship, from page 179, when it was served to me in 2024, I became aware for the first time that there had been a declaration of fraud by Axis Bank on 24/12/2020. The entire procedure was carried out behind my back. After coming to know of this, Lordship, we filed a writ petition before this honorable court. It was conceded by Axis Bank that this entire proceeding was done without even a show cause notice being given to me.
So that was set aside.
That has been set aside. So, and ICICI Bank, Lordship, this again is factually incorrect because ICICI Bank dispute was settled with ICICI Bank. And we had all the documents.
And this was raised by you in the writ petition?
We had raised this in the writ petition.
Please show the pleading to that effect.
Lordship, may I place the...
So both those references of no consequence as on date.
They have, one has already been set aside by this honorable court based on a fair admission made by Axis Bank.
Please
no
show
show cause notice given, no notice given. My lord, I'll show the pleading, Lord. My lord will kindly see page 36, para 18.
Para 18E.
Lordship. In fact, AIPL had settled its account with ICICI Bank in and around December 2021, and all the securities which were held by ICICI Bank was released, and a no due certificate was also obtained.
And where is the reference to the
Lordship,
order
thereafter,
passed in the writ petition?
My lord, because this writ petition came first.
Oh, that
So
is subsequent.
that is a subsequent writ petition, and Lordship, I can give I do not have the copy of the order there, but I can give the reference, Lordship.
Why you don't have the copy?
My lord, I don't have the copy of the order passed in. I only have a soft copy, Lordship. If Lordship kindly grants an opportunity, we'll get the copy. Lordship, this is WPA 16247 of 2024. My lord, it is a judgment dated 3rd September 2024. And in fact, Lordship, the impugned judgment was cited because this was coming up in light of the impugned judgment, where the honorable court, the same honorable single judge, was of the view that it has already been held that you have to give a show cause and you have to give the documents. Now, since in this case it's a graver case, in this it's more grave because no show cause was even granted to me. I don't even know. And Lordship, I'm just reading the relevant portion. The judgment in Rajesh Agarwal's case was referred to and in the impugned judgment, and thereafter it was held. All these steps have not been undertaken by the Axis Bank. Thus, all decisions taken, including declaration of fraud and consequential steps, are set aside. Accordingly, the writ petition is disposed of. And there again, Lordship, we did not get any blanket protection. Order will not prevent Axis Bank from proceeding in accordance with law upon compliance of the requirements as discussed above, which is show cause, documents, and a hearing.
Yes.
And Lordship, just one last in Rajesh Agarwal's case, I just want to point out where it has been specifically held that it is hearing and not heard. Lordship will see para 79 at page 295.
294.
Lordship, it starts at 294.
At 295.
At 295, did not provide an opportunity of hearing to the borrowers before classifying their accounts as fraud. And Lordship will see throughout this judgment and Lordship will kindly see para 81 at 296, which starts at 296 at 297. Lordship will see Roman 5. The application of audi alteram partem cannot be impliedly excluded under the master direction on fraud in view of the time frame contemplated under the master directions on frauds, as well as the nature of the procedure adopted. It is reasonably practicable for the lender banks to provide an opportunity of a hearing to the borrowers before classifying their account as fraud. But this follows after giving me the documents, including the audit report, which has admittedly not been done in the instant case.
Yes.
Therefore, Lordship, the impugned order should be upheld because there is nothing prejudicial to the bank in this case. They are at liberty to resume their proceeding from the identification stage. Grateful, Lordship.
One line in reply, the show cause notice, the entire incident, so the factors of the fraud angle were clearly mentioned, and that has been specifically dealt with by the writ petitioner, and one of them was also accepted by her. The point 1 was accepted by her. And
Page 79, para 6.
yes,
Correct?
page 79, para 6, yes.
With
Absolutely.
regard to point
Yes,
number 1.
we do not deny the mentioned fact.
We do not deny the
Yes.
mention.
And Lordship will kindly also, I will just indicate that the clarification says by the Honorable Supreme Court says that it is the conclusions which are pointed out or indicated in paragraph E are the final conclusions. And the conclusion says borrowers must be served with a notice, given an opportunity to explain the conclusions of the forensic audit report. Most respectfully, that was done. And even if not done, my most respectful submission would be that that should have been made part of these proceedings, and not the entire declaration should not have been set aside at this stage.
Yes, sir. Please come.
But only in paragraph 79 in Rajesh Agarwal, it is said that the copy of the report has to be given.
You are noted, sir. You are noted, sir. Unless we read faster than you, you cannot control both of you.
True.
This intra-court appeal by the State Bank of India, the respondent in WPA 10601 of 2024 is directed against the order dated 7/8/2024. The respondent filed the writ petition challenging an order passed by the appellant bank, declaring their bank account as fraud. The order was put to challenge on the ground of violation of principles of natural justice, or in other words, the rule of audi alteram partem was not followed. The learned single bench, after considering the facts of the case, took note of the recent decision of the Honorable Supreme Court in State Bank of India and others versus Rajesh Agarwal, Civil Appeal number 7300 of 2022, dated March 27, 2023, and allowed the writ petition not in toto, but by setting aside the declaration of fraud of the writ petitioner's bank account and directing the appellant bank to furnish the decisions of the ICICI Bank and the Axis Bank to the extent available with the appellant, and also the 2 forensic audit reports to be supplied within a time frame, and the appellant and the writ petitioner be allowed an opportunity to file additional reply before the committee by dealing with those documents and the committee will then proceed with the matter in accordance with law and pass a recent order. The learned advocate appearing for the appellant, after elaborately referring to the facts, contended that it is not a case, the case on hand is not a case where there was no opportunity granted to the appellant, writ petitioner. At best, it can be termed to be not a case, termed to be a case where adequate opportunity was not granted to the writ petitioner. And in any event, the writ court ought not to have interfered with the decision taken by the committee declaring the writ petitioner's account as fraud, inverted comma. Further, it is submitted that opportunity of hearing shall not always be construed to be an opportunity of personal hearing, and such interpretation is not in consonance with the decision of the Honorable Supreme Court in Union of India versus Jesus Sales Corporation, 1996, 4 SEC, page 69. Further, it is submitted that the principles of natural justice cannot be put in a straitjacket formula, and even assuming certain reports were not furnished to the writ petitioner, that by itself will not be a ground to set aside the decision of the appellant bank, as the writ petitioner has to prove prejudice on account of non-supply of the reports or materials or documents. To support such contention, reliance was placed on the decision of the Honorable Supreme Court in Managing Director ECIL versus B. Karnakar, 1993, 4 SEC 727. Further, reliance was placed on the decision of the Honorable Supreme Court in Ganesh Santaram Sirur versus State Bank of India, 2005, 1 SEC 13 for the same proposition, where the decision in B. Karnakar, decisions in Jesus Sales Corporation and B. Karnakar were referred to. The learned advocate appearing for the appellant bank has drawn our attention to the reply given by the respondent writ petitioner dated 8th February 2022. The decision taken by the appellant bank declaring the writ petitioner's account as fraud as intimated to the writ petitioner by a communication dated 13th March 2024 along with the speaking order and other related documents. The learned advocate appearing for the respondent writ petitioner submitted that no blanket protection was given to the appellant, to the writ petitioner, and a reading of the impugned order will clearly show that the learned single bench has remanded the matter back to the bank with certain directions which can never said to prejudice the rights of the bank. Furthermore, the decision in Rajesh Agarwal holds the field, as the said decision pertained to interpretation of the master circular issued by the Reserve Bank of India, where declaration of a bank account of a borrower as fraud. Furthermore, it has been observed in the said decision that declaration of a bank account as fraud has serious civil consequences, and it has been held to be a case of a civil death. Furthermore, it is submitted the question of waiver would not apply in the light of the authoritative pronouncement in the authoritative pronouncement of the Honorable Supreme Court in the case of Rajesh Agarwal. With regard to the reference to the declaration made by ICICI Bank and Axis Bank declaring the writ petitioner's account as fraud, the appellant had no knowledge of the said orders, and only after they received the intimation notice dated 13th March 2024, they became aware of it. And so far as the ICICI bank account is concerned, the same was fully settled during December 2021, and all securities which were held by ICICI Bank was released, and no due certificate was also obtained from ICICI Bank. And there is a specific government in paragraph 18 within bracket small d of the writ petition, which was not controverted. So far as the declaration of fraud by the Axis Bank, which has been mentioned in the intimation dated 13th March 2024, the writ petitioner had no knowledge of the same, and after they came to know of the said declaration for the first time in March 2024, they immediately filed a writ petition before this court in WPA 16247 of 2024, and by order dated 3/9/2024, the learned writ court had set aside the order, however, making it clear that the order will not prevent the Axis Bank from proceeding in accordance with law upon compliance of the requirements as discussed in the said order. We have elaborately heard so. The decisions which have been relied on by the learned advocate for the appellant explains the principles of natural justice and the rule of adi alteram partem. But in the case on hand, we are specifically concerned about a declaration of a account of the writ petitioner's account as fraud. Therefore, we are to we are to test the correctness of the order of the decision of the appellant bank as well as the order passed by the learned writ court based on the decision which is closest to the facts and circumstances of the case. And if that be done, then we are to be guided, and we are bound to follow the decision of the Honorable Supreme Court and Rajesh Agarwal and others, as the said decision specifically arises out of a challenge to the Reserve Bank of India within bracket frauds classification and reporting of commercial banks and select FIs, financial institutions. Bracket close directions 2016, which is commonly known as master directions on fraud. Therefore, the learned single bench cannot be faulted for having followed this decision. In the conclusions drawn in the said decisions are in paragraph 81, of which subparagraph paragraph 81. With regard to whether the lender bank, with regard to the procedure to be followed by the lender bank, the Honorable Supreme Court has issued directions which are contained in paragraph 79 of the judgment, which is quoted here in below, page 294, 295, page 79, para 7. As mentioned above, the conclusions are contained in paragraph 81 of the judgment, of which the 81 of the judgment is also quoted here in below, entire para 81. Thus, in terms of the above directions, the writ petitioner was entitled to the copies of the forensic audit report, which has been referred to. In fact, the writ petitioner in their reply dated 8th February 2024 have stated about the two forensic audit which was conducted, and they also stated that they presume the chartered accountants who conducted the forensic audit have submitted their report to the bank. This clearly would show there is no question of waiver on the part of the writ petitioner, as the writ petitioner was not privy to the said report. In any event, as per the directions issued by the Honorable Supreme Court, the reports are to be furnished to the respondent writ petitioner, and there is no escape from the said proceedings. As mentioned above, the decisions which were relied on by the learned advocate appearing for the appellant bank arose under different statutes, and though laid on the legal principle with regard to how the doctrine of audio alterum partem has to be interpreted, we are required to follow the decision which is closest to the decision of Rajesh Agarwal, since that concerned is interpretation of the master directions on fraud. Therefore, the learned single bench was right in issuing the impugned directions. However, we note that since the account with the ICICI Bank has been fully settled and no due certificate has been issued by ICICI Bank, the respondent bank, when they proceed further as per the directions of the learned single bench, are not required to rely upon the said declaration. And so far as the declaration by the Axis Bank is concerned, the same having been set aside in WPA 162/47 of 2024, dated 3/9/2024, there shall be no reference to the said report unless and until the appellant bank comes to know that fresh action has been initiated by Axis Bank on the writ petitioner. If such is the such is the factual position, then it is needless to state that copy of those proceedings, as much as they are available with the appellant bank, should be furnished with the furnished to the respondent writ petitioner. Thus, in the light of the above discussion, we find no good grounds to interfere with the impugned order. Accordingly, appeal fails. Yes, thank you.
Grateful.
Grateful.
Well, item number 4 is the same. It's the company which is the party. It's
So
identical.
it can be a common judgment.
Lordship, as my lord. Grateful, my lords. Grateful.
Deeply obliged.
Yes.
Serial number 5.
Actually, I'm appearing for Union of India, led by Mr. Anil Kumar Gupta.
I appear on behalf of respondent number 3, my lord, in the appeal. Managing Director, Devas Garage.
I'm for the Bank of India, my lord. My lord, I'm appellant, appearing in person, my lord. My lord, I have challenged the single bench order dated 15 March 2000, January 2025 in WPA number 26983 of 2024. My lord, due to a dispute over the delivery of a car, I filed a consumer complaint case before the District Consumer Commission at Baraipur, South 24 Paragana. My lord, the president of the Consumer Commission is accused in a criminal case where I am the de facto complainant of that case. As per the principle of nemo debit, SS judex in propria causa, no one should be judged in their own cause. The president cannot hear my other case, my lord, pending the case before the commission. After a physical assault, my lord, I filed a transfer application before the state commission. And to avoid further altercation and seek the transfer of the case CC 79 of 2020 from Baraipur District Consumer Commission to any other district commission for fair trial and getting justice. The transfer application was filed 24th March 2023 and rejected on 21st August 2024. During the pendency of the transfer application, my lord, before the state commission, the district commission repeatedly passed biased order. On 2nd May 2023, 18 May 2023, and 2nd June 2023. My lord, page number 100, 101, and 102 and 3. It is my fundamental rights, my lord, as per Section 48 of the Consumer Protection Act 2019, to seek the transfer of my case from one district to another district in the interest of justice and fair trial. My lord, I have filed transfer application before the State Commission, NCDRC, and Honorable High Court, Calcutta. How is it possible during the pendency of the transfer application for me to proceed with the trial
in the below court or commission. If I continue the said trial, my transfer application will become infructuous. I can provide regular updates regarding the status of the upper court's result and cannot proceed until the final order on the transfer application are issued, my lord. When the president become personally involved in the dispute and altercation leading to the assault on me, he cannot hear the case in which he is an interested party, my lord. This would be a violation of the principle of nemo debit, esse judex in propria causa. My lord, on 29th October 2024, the appeal was rejected by the NCDRC, my lord. Subsequently referred to the Honorable High Court, I did not come here to bypass any forum, my lord. Pursuant to the direction of the NCDRC, my lord, I filed the writ petition, which is subject matter of the transfer application. During the pendency of this writ petition, I filed application 3 times before the District Commission to seek adjournment of the complaint case until disposal of the writ petition. My lord, page number 117 to 123. Yes, my lord. This is the application. But District Consumer Commission intentionally dismissed my original complaint case and imposed a heavy cost of rupees 10,000, despite being knowing everything, my lord. The writ court is not fact-finding court. My prayer was transfer of the case from one district to another district. But the writ court single bench wanted to settle the matter. Yes, my lord, I was ready and I am ready to comply comply after the conclusion of the trial. Ultimately, the writ court disposed of the matter without remedy. My lord, the trial concluded by the District Consumer Commission without hearing my side, my lord, is perverse. I went to the State Commission, my lord, and filed an appeal solely to save the limitation I have filed against the perverse order and not to proceed with the trial of the case. However, the State Commission granted stay, my lord, which annex order said, yes, last I have annex. I did not receive the car, my lord. The dealer took money. The bank deducted 28 EMI from my account. My lord, transfer application was rejected and my original complaint case also rejected with a heavy cost of rupees.
This first appeal is against the district forum's order
My lord,
dismissing your appeal, complaint with cost.
no first appeal. This is my original complaint case. Yes. After rejection,
there are 2 proceedings, sir. One, you filed a larger complaint before the district forum. Or for certain reasons, you wanted that to be transferred. You filed a miscellaneous application. Correct?
Yes, right. First time.
Transfer
Application, State Commission rejected my transfer application.
The State Commission rejected. You went to the National Commission.
Yes, my lord.
They said this is not arising out of an order based on a complaint. Therefore, revision will not lie. Constitutional Court only you should approach. But in the meantime, the district forum dismissed your complaint.
During the pendency.
Yes. That was challenged and the last page. And stay order granted.
I have challenged on the writ court, single bench order. No, my lord. Yes. Only for this appeal, I have filed a safe to limitation.
But stay order has been granted.
Yes, stay order has been granted by the State Commission.
So now, if suppose we allow your writ petition and transfer it, what will be the fate of this appeal? Because the transfer application was rejected by the State Commission. That order was confirmed by the National Commission. Meantime, you have suffered an order of the State Commission. Probably in the State Commission, you can ask for setting aside the order and posting the matter to a different district forum. Suppose even if you allow your
yes, my lord.
Now, what is there to be transferred? a case can be transferred from court A to court B if it is pending in court A. Now the matter is no longer pending before the district
This
court.
is perverse order, my lord. Because during the pendency of the transfer.
No,
My
no,
lord, my
we are not referring to your case, sir. We are referring to a principle. When a transfer can happen, a case should be pending before A court. For X or Y, Z reasons, you want it to be transferred to a B court.
Yes, my lord.
Now, your complaint is no longer pending before the district forum. How to transfer that? That has already, an order has been passed.
My lord, my submission only during the pendency of transfer application. Can the district commission pass any order?
That order has not come under challenge.
already তো ওটাকে dismiss
না,
করে দিয়েছে।
তাহলে কি হয়েছে?
সেটাকে
আমার বক্তব্য হচ্ছে
challenge হয়নি।
during the during the pendency of the writ petition being the subject matter of the transfer application, the below court or tribunal can dismiss my original complaint case because I have filed 3-time application and seek adjournment until disposal of the transfer application.
Appeal
But
has been preferred. This appeal has been preferred against the order dated 15th January 2025.
2024, yes, my lord.
But in during pendency of this matter, your original complaint
Dismiss
also
along with
dismissed.
cost. Yes.
So thereafter, whether have you challenged that order before any forum? No.
The state commission.
No, my lord,
State
my lord,
commission.
my
State
yes,
commission
yes,
stay
I understand. I understand.
So what we can do is, we can make an observation that you can make this prayer, because as of now, we cannot transfer, but the state commission can consider the grounds stating that an perverse order was passed without opportunity and may take a decision on
My
merits.
lord, my what is the result of my transfer application?
Admit.
যেটা বলছো না, শোনো না, তোমার ভালো হবে এটাতে।
Next.
ডিরেকশন দিয়ে দেবে।
Serial number 6.
স্টেট কমিশনকে ডিরেকশন দেবে তোমার এটা শোনার জন্য। সেটাই বলছি। তোমার ভালো হবে।
My lord, the only thing is the writ petition is
My lord,
pending, my lord. It is not disposed of. The writ petition is pending before the single bench.
My lord, kindly direct.
Still pending.
Yes, my lord.
Against what order he has come?
The order, if my lord sees the impugned order, the impugned order only says the parties to make an attempt to settle the matter. The writ petition is pending. It is not that the writ petition has been disposed of.
We were under the impression writ is still pending.
Yes, my lord.
Single bench, my lord. Already disposed of my certificate copy annex.
So all right, we'll admit the appeal.
15-125 disposed.
Question of ground.
No, dispose of my lord. Then thereafter I have.
The question of stop with this.
দর্শক তোমার যেটা বলছিল ওটা তোমার ভালো হবে। হাইকোর্টের ডিরেকশন যেহেতু তোমার স্টেট কমিশনের উপরে স্টেট কমিশন।
I apologize, my lord.
Item 6 অ্যাপিল অ্যাডমিট করে রেখে দিলে পরে তোমার তাতে লাভটা কি হবে? তাহলে তোমার লাভটা কি হবে? বলে তোমাকে বলছি।
My lord, may I have my lord's kind leave? My lord, item number 20. My lord, I have some difficulty on Monday. My lord, can it be on Wednesday? So grateful.
Lordship, my lord, sorry, my lord, mentioning. My lord, one writ petition GST matter, my lord, very urgent. My lord, I mentioned, my lord, today before court 759, my lord, but mention not allowed. Challenging here, my lord, the show cause notice, date of hearing fixed on next Tuesday, my lord. And urgency is that, my lord, for 17, 18, 18, 19, 19.
Give a letter, adjournment letter, and serve copy on the government council. They can advise. I can't do anything at this.
পাঠক দা